Florida has transformed into the most aggressive immigration enforcement state in America, and 2026 is becoming the year where everything intensifies. If you work in Florida, rent property here, employ anyone, or live as an immigrant in this state, what has been building since 2023 is now reaching a critical point. We're talking about state-run detention facilities called Alligator Alcatraz and Deportation Depot, over 10,000 arrests through Operation Tidal Wave, new laws that could strip workers' compensation from undocumented employees, and tip lines where your neighbors can report you to state authorities. This is not speculation. This is happening right now under Florida law, and if you don't understand the full scope of what's unfolding, you could find yourself caught in a system that shows no mercy. Stay with me because what I'm about to reveal will change how you see this state forever. Florida's Operation Tidal Wave has become the largest joint immigration enforcement operation in ICE history. In January 2026, Governor Ron DeSantis announced that Operation Tidal Wave had resulted in over 10,400 arrests since it launched 8 months earlier. This isn't just another enforcement campaign. This is a first-of-its-kind partnership where Florida state agencies work directly with ICE under 287G agreements, exercising immigration authority that has historically been reserved exclusively for the federal government. The breakdown of those arrested tells a story. Over 3,400 individuals from Guatemala, more than 3,300 from Mexico, nearly 1,400 from Honduras, and hundreds more from El Salvador, Venezuela, and other countries. Florida law enforcement agencies across multiple counties have been directly involved, including Alachua, Baker, Bradford, Brevard, Clay, Hernando, Hillsborough, Indian River, Orange, Pinellas, St. Johns, Sumter, and Volusia counties. Every county jail in Florida has now signed a written agreement with ICE to ensure 287G compliance. This means when you're arrested anywhere in Florida for any reason, your fingerprints are automatically checked against immigration databases. If there's a match, ICE gets notified immediately. The state has created a seamless pipeline from arrest to deportation, and it operates around the clock. Florida didn't just increase enforcement, it built physical infrastructure to handle mass detention. The state now operates 2 immigration detention facilities with names that sound like they came from a dystopian novel. Alligator Alcatraz, officially called the South Florida Detention Facility, sits at the Dade Collier Training and Transition Airport inside Big Cypress National Preserve in Okeechobee. Then there's Deportation Depot, located at the former Baker Correctional Institution in Sanderson, which opened in September 2025 and can hold up to 2,000 detainees. Governor DeSantis claims the state equipped Deportation Depot for around $6 million, calling it a fraction of what similar facilities cost elsewhere. But here's what makes this terrifying. If you're detained and sent to one of these state-run facilities, you won't appear in the standard ICE online detainee locator system that families use to find loved ones. As of now, there is no searchable public database for people held at Alligator Alcatraz or Deportation Depot. Family members have reported that their loved ones simply disappeared into these facilities. A Democratic state senator has proposed legislation requiring a public database of immigration enforcement actions, but that bill faces an uphill battle in the Republican-controlled legislature. Meanwhile, Florida is waiting for federal approval to open a 3rd immigration detention center. The state's detention capacity is expanding while transparency shrinks. The foundation of everything happening in 2026 was laid by Senate Bill 1718, which Governor DeSantis signed in May 2023. That law fundamentally changed how Florida handles immigration by creating criminal penalties and civil requirements that affect landlords, employers, hospitals, and anyone who interacts with undocumented individuals. SB 1718 made it a 3rd-degree felony to knowingly harbor undocumented immigrants, which includes landlords who rent to them. It required hospitals receiving Medicaid to ask patients about their immigration status and report that data quarterly to the state. It mandated E-Verify for private employers with 25 or more employees, and it made transporting undocumented immigrants into Florida a felony. But that was just the beginning. In February 2025, Governor DeSantis signed two more laws, SB 2C and SB 4C, that dramatically escalated penalties. SB 4C makes it a first-degree misdemeanor for undocumented immigrants who are 18 or older to knowingly enter or attempt to enter Florida. For those with prior deportation orders or criminal history, prison terms can increase to 2 or 5 years. And here's the provision that has drawn the most attention. SB 4C requires courts to impose the death penalty for any undocumented immigrant convicted of a capital felony like first-degree murder in Florida. This makes Florida the only state in America with a law specifically mandating capital punishment based on immigration status. While courts have temporarily blocked parts of SB 4C due to constitutional challenges, the law remains on the books and enforcement could resume at any time. The 2026 Florida legislative session is pushing immigration enforcement even further. A bill that already passed the Florida House would require all private employers, regardless of size, to use E-Verify for every new hire. This expands the existing law that only applied to businesses with 25 or more employees. Under this new requirement set to take effect July 1, 2026, even if you run a small business with just one employee, you'll have to verify that person's work authorization through the federal E-Verify system. Violations aren't just fines. For a first offense, your business license can be suspended for up to 1 year. For a second violation, it's permanently revoked. But the proposed legislation goes beyond E-Verify. State Chief Financial Officer Blazing Goglia introduced a massive immigration package that would ban undocumented workers from receiving workers' compensation entirely. If you're an employer who hires an undocumented worker and that person gets injured on the job, you would have to pay out of pocket for their injuries. The legislation would also prohibit undocumented immigrants from opening bank accounts with state-chartered financial institutions. It would ban them from down payment assistance programs and home mortgage programs. It would require all commercial driver's license testing and instruction to be conducted exclusively in English, and it would force insurance companies of undocumented drivers to accept fault automatically if they're involved in a car accident in Florida. These proposals are moving through the legislature right now. The housing situation in Florida has become a legal nightmare for both landlords and tenants. Under SB 1718, landlords who knowingly rent to undocumented immigrants face third-degree felony charges, which means up to 5 years in prison and a $5,000 fine. This has created widespread fear and confusion. Many landlords are now requiring documentation beyond standard rental applications, including passports, green cards, work visas, or proof of citizenship. Some are using E-Verify systems that were designed for employment verification. If you can't provide these documents, you may be denied housing even if you have perfect credit and cash in hand. A survey by John Burns, research and consulting for the National Apartment Association, found that 67% of Florida landlords reported negative impacts from immigration policy enforcement. One Miami-Dade landlord reported his properties went from a typical 2% vacancy rate to 30% because tenants disappeared. Some simply stopped showing up. Others left voluntarily out of fear. The rental market in immigrant-heavy areas is experiencing vacancies because people are fleeing the state entirely. But here's the legal trap. If a landlord uses immigration status verification to discriminate based on national origin, that violates the Federal Fair Housing Act. Landlords argue they're simply trying to avoid felony charges under state law. Tenants are afraid to assert their rights because doing so might trigger an investigation into their status. The conflict between federal fair housing protections and Florida's state enforcement creates a minefield where discrimination is rampant, but nearly impossible to challenge. Florida has created something unprecedented in modern American history. The Florida Department of Law Enforcement established a tip line in March 2025 called the Law Enforcement Accountability Dashboard, supposedly designed for officers to report agencies not complying with immigration enforcement policies. But records obtained through public records requests reveal something disturbing. Many of the tips submitted weren't about police misconduct. They were about neighbors, community members, and acquaintances suspected of being undocumented. One person complained about their son's bus driver being foreign. Multiple tipsters used the system to air personal grievances and family disputes. One lengthy submission detailed allegations that a spouse had committed marriage fraud. A Lake Worth Beach resident reported Haitian neighbors who throw loud parties, speculating that the partygoers may not be here legally. A Fort Pierce resident complained about large parties in a cattle pasture with very loud music, all in Spanish. This tip line has essentially become a tool for neighbors to report each other to state authorities based on suspicion, accent, appearance, or the type of music they play. Historians who study immigration policy have compared this to climates of suspicion that characterized authoritarian governments. The National Police Accountability Project noted that no other state has created such a tip line. Even Texas doesn't have one. Meanwhile, the Florida Attorney General's office created a separate tip line called the Combat Violent Extremism Portal, which has already received over 6,400 pages of responses. Florida is building an infrastructure of surveillance that depends on citizens informing on each other. The impact on Florida's economy is becoming impossible to ignore. Non-citizens make up approximately 1/3 of Florida's construction workforce and nearly half of farmhands. A large share of these workers are undocumented. With aggressive enforcement, these industries are facing labor shortages that threaten Florida's economy at its foundation. Agriculture is being hit particularly hard. Florida produces nearly half of America's citrus and significant portions of tomatoes, strawberries, and other crops. Farmers reported that intense immigration enforcement is creating fear even among employees who work on legal H-2A visas. Workers are hesitant to come, and some are not returning. NPR reported that some Florida farmers are reducing their crop production because deportation fears have driven workers away. Construction is experiencing similar disruptions. Around 34% of construction trades workers nationally are immigrants, with some specific trades seeing shares as high as 61%. In Florida, undocumented workers aren't being rounded up in dramatic workplace raids. They're simply not showing up to work anymore, either because they've been apprehended, self-deported, or are too afraid to leave their homes. The Associated Builders and Contractors reports that many contractors haven't replaced this talent, driving up costs across the industry. The tourism and hospitality sectors, which are central to Florida's economy, also depend heavily on immigrant labor. Hotels, restaurants, and theme parks are all feeling the strain, and the ripple effects extend beyond specific industries. Fewer foreign-born workers means fewer people buying at stores, fewer people paying rent, fewer people seeking health care, and reduced tax revenue across the board. Something that most people don't realize is that legal residents are also at risk. If you have a green card, you might think you're protected from deportation. That's a dangerous assumption. Under federal immigration law, lawful permanent residents can be deported for committing certain crimes, including what the law calls aggravated felonies and crimes involving moral turpitude. Florida has one of the broadest definitions of criminal conduct in the country. Actions that might be misdemeanors elsewhere can be felonies here. Drug possession, theft over $300, domestic battery, and DUI with injury can all trigger deportation proceedings. And the definition of aggravated felony under immigration law is far broader than most people understand. It includes offenses like shoplifting if the sentence imposed is 1 year or more, even if that sentence is suspended. It includes simple battery if it's classified as a crime of violence. Florida has not decriminalized marijuana possession, and even a misdemeanor conviction can trigger deportation for a green card holder. DACA recipients are also facing heightened risks. Immigration attorneys report that DACA holders with any criminal records are being detained despite their protected status, and deportation proceedings are being initiated. Temporary protected status holders from multiple countries face uncertainty as their designations may not be renewed. Over 1 million immigrants with TPS nationwide are at risk of losing their legal status in 2026. Florida immigration courts have some of the lowest asylum grant rates and highest deportation rates in the country. If you're any type of immigrant in Florida with any kind of criminal history, no matter how minor or how long ago, you need to understand that you are not fully safe. The humanitarian impact on families is devastating. Mixed status families, where some members are citizens and others are undocumented, are facing impossible choices every day. Do you drive your child to school knowing that a traffic stop could lead to deportation? Do you take your spouse to the hospital knowing they'll be asked about immigration status? Do you report being a victim of a crime knowing that contact with police could tear your family apart? For many families, the answer is increasingly no. Florida's K-12 enrollment dropped by more than 46,000 students, and state reports indicate this is most likely because of immigration enforcement. Parents are keeping children home out of fear. Hospitals are seeing fewer patients seeking care. Crime victims are refusing to cooperate with police investigations because they fear deportation more than they fear the criminals who victimized them. The Department of Housing and Urban Development has ordered landlords to verify citizenship for subsidized housing tenants within 30 days, potentially taking rental assistance away from nearly 200,000 families. Children in mixed-status families experience documented psychological trauma, including anxiety, behavioral changes, and developmental impacts when family members face detention or deportation. And when a primary breadwinner is arrested, entire families are thrown into financial chaos overnight. Churches and nonprofits that have traditionally provided assistance to immigrants are now worried they could face harboring charges under SB 1718 simply for offering shelter or food. The SB 2C law created the State Board of Immigration Enforcement, which coordinates with federal agencies and directs state law enforcement in immigration matters. This board has been allocated more than $298 million for immigration-focused law enforcement, including funding to hire 50 new officers, bonus programs paying $1,000 to officers who participate in immigration enforcement, and training grants. Governor DeSantis has spent at least $573 million on immigration enforcement overall. The state received $608 million from FEMA to cover immigration enforcement costs. Florida sheriff's departments are receiving large checks for participating in 287G agreements with ICE. The Polk County Sheriff's Office alone received over $1 million. This isn't just policy, it's an industry, and it's being funded at levels that ensure it will continue and expand regardless of the human cost. Every local law enforcement agency in Florida is now required to cooperate with federal immigration authorities. They must honor immigration detainers, which hold people in custody for up to 48 hours beyond their scheduled release, so ICE can pick them up. Florida prohibits sanctuary city policies, and any local government that restricts cooperation with federal enforcement can lose state funding. Elected officials who implement such policies can be removed from office. The state attorney general has already subpoenaed the city of Jacksonville over alleged non-compliance with immigration enforcement. No jurisdiction in Florida is allowed to opt out of this system. The laws targeting documents and identification have expanded. Florida already invalidated driver's licenses from Connecticut, Delaware, Hawaii, Rhode Island, and Vermont if those licenses were issued to someone without proof of legal presence. If you're driving in Florida with one of those licenses, you're driving without a valid license under Florida law. You can be pulled over, cited, arrested, and have your car impounded. This affects not just immigrants, but also visitors and people relocating from those states. The new legislation being considered would require all commercial driver's license testing to be conducted exclusively in English, eliminating accommodations that have existed for decades. Using false documents remains a serious crime under Florida Statute 8117.5-68. If you're convicted of using a fake social security number or forged immigration documents, you face third-degree felony charges. But Florida prosecutors now work directly with federal immigration authorities. An arrest for document fraud triggers both state charges and federal immigration violations. It doesn't matter if you've lived in Florida for decades, own property, or have citizen children. The use of false documents, even from many years ago, is a deportable offense. Florida is not showing leniency. If you've made it this far, you now understand what most people in Florida still don't grasp. These aren't theoretical possibilities or political talking points. These are laws that have been signed, funded, and are being actively enforced across this state. Whether you're an immigrant, a landlord, an employer, a worker in construction or agriculture, a legal resident with any criminal history, or simply someone with immigrant neighbors, these policies affect your daily life. Florida has positioned itself as the national model for aggressive immigration enforcement, and other states are watching to see if they should follow. Governor DeSantis has called Florida the gold standard that other states should replicate. The infrastructure of detention facilities, tip lines, law enforcement partnerships, and sweeping legislation creates a system designed to identify, detain, and remove people at scale. The economic disruptions are already visible in labor shortages, housing vacancies, and declining school enrollment. The human costs are measured in separated families, traumatized children, and communities living in constant fear. This is the reality of Florida in 2026. If this video helped you understand what's really happening, hit that like button. Subscribe, because I'll continue covering Florida laws that mainstream coverage oversimplifies or ignores entirely. Drop a comment and tell me, do Florida's immigration laws protect public safety or do they go too far? Share this video with anyone who lives in Florida, works in Florida, or has family in Florida. They need to know what they're dealing with. Information is the only protection many people have left. Stay informed, stay alert. I'll see you in the next one.